Good afternoon. Here is everything about family law for the bar, from premarital agreement to property division at divorce. Let's remember that every single time we start an MEE essay, we are going to state the source of law. So we begin with premarital agreements. Our source of law is the Uniform Premarital Agreement Act, or UPAA. Remember, a premarital agreement is a contract like any other. And so we need offer, acceptance, consideration is the marriage itself. It needs to be signed. It needs to conform with the statute of frauds. All people have to have the capacity to contract. In other words, to enter a premarital agreement, you can't be underage, you can't be impaired, there can't be any duress, and there can't be undue influence. And there are a couple of things that you cannot pre-contract. Big one, child custody and support. You cannot pre-contract child custody and support. If we're talking spousal support, that is going to vary by jurisdiction. Okay, what's our source of law? That's right, the Uniform Premarital Agreement Act, UPAA. And we need what elements? Offer, acceptance, consideration, which is the marriage itself. It needs to be signed, needs to conform with the statute of frauds, and all people have to have, that's right, the capacity to contract. Okay, premarital agreements, are they presumed enforceable? Yes. Yes, they are presumed enforceable when they are entered into voluntarily and with fairness and with full disclosure of all material facts. Enforceable voluntarily and with what? Fairness, with full and fair, that's right, disclosure of all, that's right, material facts. And the agreement must be reasonable. When would an agreement not be enforceable? When there's evidence of your common contract offenses, the most common being duress, unconscionability, fraud, overreaching, undue influence. Okay, so remember your contract defenses when you're talking about premarital agreements. Undue influence, pressure, duress, threats of future harm, or threats regarding the marriage. Unconscionability, it's so unfair or lopsided in favor of one party, or one party has unequal bargaining power. And it has to be reasonable. Okay, do both parties need counsel? No, not necessarily. But if both parties have counsel, that's going to count toward the enforceability of your premarital agreement. All right, what do we have? 1, voluntarily, that's right, and with fairness. 2, full and fair disclosure of all material facts. 3, no evidence of our contract offenses, fraud, duress, undue influence, unconscionability. Both parties have, that's right, counsel, and the agreement is reasonable. Okay, so under the UPAA, remember, why do we pre-contract this stuff? It can be unfair. It just can't be unconscionable. So an unfair agreement will be enforced, but an unconscionable agreement, so unfair or lopsided that it shocks the conscience, will not be enforced. Okay, so when enforcing a premarital agreement, the court is going to look for several factors. Number 1, timing of the agreement. When is it presented? A premarital agreement that is presented 30 days before marriage is presumably valid if everything else is in place. And then we look at the surrounding facts and circumstances. Okay, so we're going to look at the parties, their age, education, business experience, their situation, their respective property, their family ties. Okay, so that's a fact-specific inquiry. These are just some of the factors. So let's name some of them. age, education, business experience or legal experience, their property, and their family ties or connections. Is one party, what are we looking for? Is one party older, more powerful? Do they have better connections? Do they have good counsel? Are they trying to, what are they trying to do here? Is one party younger? Is one party one party has less education? One party has significantly less property. Remember, if it's unfair, it'll be enforceable. But if unconscionable, shocks the conscience, unfair, lopsided, never enforceable. Okay, so who has the burden of proof when a premarital agreement is challenged in court? Well, you guessed it. It is, of course, the challenger, the plaintiff. And what's the challenger going to try to disprove? They're going to try to prove there was no fair and reasonable disclosure of all material facts, that they didn't waive the right to that disclosure, and that they couldn't have known about anything that was undisclosed. Who has the burden? The challenger. What are they going to argue? No fair and reasonable financial disclosure. They didn't waive it. No way they could have known about it. Okay, so when is a premarital agreement presumed enforceable? When executed 30 days prior to marriage, both parties had counsel, and there is full and fair disclosure of all material facts. All right, we're going to repeat all that one more time and move on to the next topic. What's our source of law? That's right, the Uniform Premarital Agreement Act. What can't we pre-contract? That's right, child support, child custody, and in some jurisdictions, spousal support. When are they enforceable? Presumed enforceable where entered into 30 days prior to marriage. That's not dispositive. Voluntarily and with fairness, that's right, full and fair disclosure of all material facts. Both people have counsel, and there's no contract defenses that would apply. Undue influence, fraud, duress, unconscionability. Okay, so what are we going to look at when the court is considering a premarital agreement? Number one, that's right, it's timing. When is it presented? Number two, the surrounding facts and circumstances. Who are these people? What are some of the factors? Age, education, business experience, legal experience, their property. That is a fact-specific inquiry. And then we're going to look at our burden of proof. Who's got the burden of proof? That's right, the challenger. And what are they trying to prove? That's right, no fair and reasonable financial disclosure. They didn't waive that right, correct? And there's no way they could have known of undisclosed facts. All right, that was premarital agreements. Now we're going to move on to marriage. Number one, we are going to state the constitutional provisions for marriage. In your MEE essay, marriage is a fundamental right. We are going to cite Loving versus Virginia and Obergefell versus Hodges. Number one statement, marriage is a fundamental right. Loving versus Virginia, Obergefell versus Hodges. So what do we need? We need an agreement to marry, an offer and an assent made by parties competent to contract. And the consideration is what? That's right, the marriage. Okay, and of course, we can't have any fraud going to the essentials of marriage. What does that mean? It usually means you can't have sex. Okay, and we're looking for no duress. So, but remember, age is going to be the number one tested factor. A marriage is voidable or void ab initio, void from the get-go. Okay, let's first talk about marriages that are just void. They never existed, have no legal effect. You don't need a legal divorce. Bigamy. Okay, that would be number one. So remember, we have our putative spouse doctrine, which we'll get to later. Incest. So people are too closely related by blood or adoption or marriage. If we have a void marriage, it is void from the get-go. We don't need an annulment. It never existed. Let's contrast this to a voidable marriage. When do we normally get this? It's when someone's underage. So it's valid until the party entitled to assert voidability timely raises the issue. Now, who can that be? The party, the person marrying underage, the person's parent or guardian, if they're underage. And what happens after they're underage? Is it automatically ratified? No, they get a short window of time, varying by jurisdiction, to void that marriage after turning 18. And what will ratify after 18? Subsequent cohabitation as spouses. Okay, so what's going to render our marriage void? Closely related by blood marriage or adoption, bigamy, polygamy, underage marriage. The other thing that can make a marriage voidable, other than age, would be age or incapacity. That could do it too. Okay, so those are our substantive requirements. So we've got marriage as a fundamental right. We need an offer and assent made by parties competent to contract. And then our number one voidable factor is going to be underage marriage. You can ratify that underage marriage by continuing to cohabitate as spouses after age 18, or within a short window, you can void that marriage within a short window after 18. If you're under 18, you can have that marriage voided or annulled, and so can your parent or guardian. All right, so what do we need to marry? The legal requirements. Well, we're going to need a license, and we're going to need witnesses, and there might be other requirements, residency requirements, health education, testing. You don't always need a legal officiant and a legal ceremony, but you definitely need the license, the witnesses, and the marriage certificate has to be registered with the state. You might need to live in the state for a certain amount of time, like 90 days, 30 days, not too long. Remember, we don't want to burden the right to travel, right? And we might have health education or testing requirements. Okay, let's move on to common law marriage. Before we talk about common law marriage, if we have a common law marriage question on the MEE, we are going to talk about full faith and credit and comity. So a common law marriage may be valid in one state and invalid in another. But regardless, an already existing common law marriage is entitled to full faith and credit. States must uphold the judgments of other states under the doctrine of comity. Okay, so what do we need to create a common law marriage? Present intent to be married, not just an engagement, not just the future. Present intent to be married, made by parties competent to contract, followed by cohabitation as spouses, subsequently holding oneself out as being married, and ownership of joint property or assets will help too. Okay, but so marriage, we're going to first say, what's our constitutional provision? Marriage is a fundamental right. What are we going to quote? Loving versus Virginia and Obergefell versus Hodges. And we are going to need our procedural requirements. It can't be void ab initio. It can be voidable, underage usually. And we need our license, witnesses, registration of the marriage certificate, and other state requirements. And the hypo is going to tell you what that is. Substantial compliance will sometimes be okay. So if you had a license, but you didn't register that license, you subsequently held yourself out as being married for 20 years, maybe the court's going to recognize that marriage. Okay, you got a license, you had witnesses, you registered your marriage, but you didn't have a ceremony. Likely your marriage is valid. Okay, common law marriage, repeat. Intent to be married in the present, made by parties competent to contract, followed by cohabitation as spouses, subsequently holding oneself out as being married, and helpful, ownership of joint property or assets. Okay, guys, putative spouse. A putative spouse. Okay, the putative spouse doctrine in family law and in trusts and estates protects a person who entered into a marriage in good faith, believing it was valid, and they may have rights to spousal support, to property, but if we have a pre-existing legal spouse, that legal spouse also counts. So that's a balancing test. So putative spouse, someone who entered into a marriage in good faith, believing it was valid, they may have rights to spousal support and property. But if the legal spouse subsequently turns up, well, they're still the legal spouse. Okay, moving on to divorce. Let's talk about a legislative divorce. The state has the power and authority to grant a divorce if one or both parties are domiciled in the state. What is domicile from CivPro? Fact of residence, intent to remain. Or if they have a relationship with the state, kind of like specific jurisdiction. When does this come up? It's a military. So domicile in itself is sufficient to dissolve a marriage. You do not need PJ over the defendant just to dissolve the marriage. So a legislative divorce dissolves a marriage when one or more parties is domiciled, fact of residence, intent to remain, or has a relationship with the state that's sufficient to dissolve the marriage itself. But if we want to adjudicate questions of kids, money, and property, we're going to need PJ over the defendant. So what do we need for PJ? We need to satisfy the constitutional requirement of the long-arm statute. We need to give the defendant notice, Mullane versus Hanover Bank, notice sufficient to apprise the defendant of the pendency of the action and afford them an opportunity to be heard. And of course, they have to be served. Okay, so what's enough for due process? Domicile, consent, waiver, tag, you can tag someone, or specific jurisdiction. And if due process is satisfied, the long arm is satisfied, and then we serve them. Okay, if you don't have PJ, you can still get a divorce, right? An ex parte divorce or legislative divorce. And all you need for that is domicile and notice opportunity to be heard. Okay, let's go over that again. Domicile is sufficient to dissolve a marriage. Do you need to give the other side notice? Of course you do. So we're going to quote Mullane, service reasonably calculated under the circumstances to apprise the defendant of the pendency of the action and afford them an opportunity to respond. If we want to deal with matters of money, property, and kids, we need PJ over the defendant. All right, so when you're analyzing a question on the MEE, look to see whether there's a question regarding kids, property division, spousal support. For all of that, we need PJ over the defendant. For just an ex parte divorce, we don't. We just need domicile, service, notice, and service. Okay, so we've got no-fault divorce in all 50 states based on irreconcilable differences, irretrievable breakdown of the marriage, all efforts at reconciliation have failed, future efforts futile and not in the best interests of the family. And you can just state your irreconcilable differences if you like. Okay, just like marriage, you can't just go to Las Vegas and get a divorce. You have to have a certain amount of residency there. And each state is going to differ as to residency requirements and separation requirements. Okay, so let's go back here. You can get an ex parte divorce if one or both parties is, that's right, domiciled in the state. We give what to the other side? Notice, and we serve them in such a way as to apprise them of the pendency of the action and afford them an opportunity to be heard. What do we need to adjudicate claims of money, property, and child support? That's right, PJ. And then, of course, we need our grounds for divorce, which is irreconcilable differences. And the state's going to possibly have two other requirements. What are they? Residency and separation. Okay, we got our premarital agreement, we got married, we got our legislative divorce, we got our regular divorce. Now let's talk about marital settlement agreements. Just like a premarital agreement, a marital settlement agreement is a contract like any other. It is a settlement that we are going to use instead of going to court. Property division, debt, reserving or waiving spousal support, it has to follow the common law of contracts. Offer, assent. The consideration is what the spouses are bargaining for. The record player, the stock portfolio, whatever. Okay, so notice I didn't say child custody and support. Child custody and child support are subject to court approval. Those can be in an MSA, but we have to have court approval for those things. Okay, moving on, we're going to talk about everything child. First of all, we're going to talk about child custody jurisdiction. And here our source of law is the UCCJEA, Uniform Child Custody and Jurisdiction Act, and the PKPA, which is the Federal Parental Kidnapping Protection Act. Okay, number one, when we're talking about child custody, we are going to state the source of law, UCCJEA and the PKPA. Where are we going to litigate under the UCCJEA? The home state of the child, where the child has resided 6 consecutive months with a parent, or under the look-back provision, where the state was the child's home state, the child's absent part of 6 months, and we've got a parent left behind in the home state. Okay, if the home state is unclear, the child has more than one home state, we can look to their significant connection state, a more appropriate forum, or in an emergency, under the UCCJEA, any state can adjudicate child custody. Okay, very important. What's our source of law? That's right, UCCJEA, and that's right, PKPA. Where do we litigate? Home state of the child, 6 consecutive months with a parent, or the look back. We've got a parent left behind in the home state, and the kid has gone out of state for less than 6 months. What if we don't have a clear home state? We're going to look to their significant connection state. What evidence do we have? Is there a more appropriate forum? And in an emergency, any state can adjudicate child custody. Okay. Do we need PJ for child custody? For an initial order, no. We do not need PJ over the defendant for an initial order of child custody. Why does that make sense? If you are escaping an abusive marriage, do you want the defendant to know where you are? No. For an initial order of child custody, we don't need PJ. However, the defendant must have notice and opportunity to be heard. And of course, we can get a temporary restraining order against that person if they, we're not going to go into OPs right now. But at any rate, okay, so our child custody initial order. So we're going to litigate that in the home state of the child. Okay, for that child custody initial order, we don't need PJ over the defendant because it's not a matter of money or property. It's a status theory determination. But what do we need for child custody? The court's going to consider the best interests of the child. Okay, forgot one important thing there. For child custody, we're going to quote our source of law. What is that? The Uniform Marriage and Divorce Act, the UMDA, the best interests of the child standard. Okay, the parent's wishes as to the child's custody, the child's wishes as to his custodian, provided they have sufficient maturity, the interaction and interrelationship of the child with parents, siblings, and other people, the child's adjustment to home, school, and family, and the mental and physical health of all persons involved. Okay, let's talk about that again. Parents' wishes as to, that's right, custody. The child's wishes as to, that's right, his custodian. The interaction and interrelationship of the kid with everyone else in his life. The child's adjustment to, that's right, home, school, and family. And the mental and, that's right, physical health of all persons involved. Okay, there is a rebuttable presumption favoring joint custody and against perpetrators of domestic violence. Okay, we just talked about the child custody initial order. We went through child custody jurisdiction, source of law, UCCJEA, 6 months, home state of the child. We talked about our initial order, which our source of law is the UMDA. We don't need PJ over the defendant because it's a status theory determination, but we do need to consider under the UMDA the best interests of the child. Okay, what about third-party custody? Okay, well, we are going to quote a couple of cases. We're going to quote Troxel versus Granville. We're going to quote Meyer versus Nebraska. A biological parent has a constitutional liberty interest in raising their own child. When can this come up? When we have parents in different states, when we have a third party or someone trying to adopt a child, when we have someone who is a step parent, we are going to look at whether we have a fit parent, because a fit parent has a constitutional liberty interest in raising their own child. Always quote Troxel versus Granville and Meyer versus Nebraska, especially if you're talking about private education. Okay, moving on. Child custody can be modified, but guess where we have to litigate? That's right, the state that issued the initial order has, say it, continuing exclusive jurisdiction. Continuing exclusive jurisdiction. What's our source of law? The UMDA. Okay, so how do we get a modification in child custody? Substantial change in circumstances after a 2-year waiting period. Substantial change in circumstances after a 2-year waiting period. We can also have consent of the other parent or serious endangerment. Okay, but in general, if we don't have anything going on that would endanger the child, we are going to look at substantial change in circumstances with a 2-year waiting period under the UMDA. Okay, so child custody modification, source of law, UMDA. What does the original court have? That's right, continuing exclusive jurisdiction. Okay, parents can relocate, but if they have a child with a custody order, then we are going to have to go back to court to relocate. What's our source of law? The Uniform Interstate Family Support Act. This will, of course, come up in child support too. A parent has a constitutional right to travel, but not to relocate absent a court order. So when can you relocate? Well, you've got to get a court order. You can relocate for a valid purpose, in good faith, to a location reasonable in light of the purpose. Valid purpose, in good faith, to a location reasonable in light of the purpose. Okay, let's go with that. Let's go after that third prong. What's reasonable? Okay, well, we're going to look at the other parent's rights. We're going to look at the child's relationship with their parents, their siblings, other adults. We're going to look at how old the child is, the impact of the relocation on the child, visitation to preserve the relationship with the other parent, and if the relocation will benefit the child in some way. Any factor that would affect the child's best interest is going to be considered for that reasonableness analysis. Okay, child custody mode modification, what's our governing law? UMDA. What does the court have? Continuing exclusive jurisdiction. How long do we need? 2 years. What do we need to show? Substantial change in circumstances or harm to the child. What's our source of law for relocation? UIFSA, Uniform Interstate Family Support Act. We can relocate for valid purpose, in good faith, to a location reasonable in light of the purpose, and always analyze the reasonableness according to the facts. Okay, let's move on to child support. Okay, so we are going to state that all children have a right to support from both parents, and our source of law is UIFSA, Uniform Interstate Family Support Act. And full faith and credit, because states must respect the judgments of other states. That goes for child support, it goes for divorce. Do we need PJ over the defendant for child support? Absolutely. It's a matter of money. For money, we need PJ. Okay, you can get an initial child support order as long as you have PJ over the defendant. It doesn't need to be the child's home state, although that is preferred. You're going to file wherever you can get PJ over the defendant. Okay, so for child support, most states are going to follow the income shares model. That's our default. So each parent paying a proportional share based on time spent with the child and the parent's income, so the child enjoys the standard of living that they had before the divorce. A minority of states will follow that percentage of income model, where they're going to grant support to the custodial parent based on a percentage of income. And okay, but let's remember that child support is tax neutral and that you can't discharge it in bankruptcy. Child support is not income to the recipient parent, and it is not deductible to the non-custodial parent. Can you modify child support? Yes. What's our source of law? Oh yes, it's UIFSA, Uniform Interstate Family Support Act, and of course, Full Faith and Credit for Child Support Act. And here, once the child support order is made, just like child custody, we have, say it, continuing exclusive jurisdiction from the state that ordered it. Do we need PJ? Yes, we're talking about money. However, UIFSA gives us a few different ways to establish PJ. If the defendant formerly resided in the state with the child, helped conceive the child in the state, or asserted parentage or gave birth to the child in that state. Excuse me. Okay, so remember our additional ways to get PJ for child support. The defendant formerly resided in the state with the child. The defendant helped conceive the child in the state, asserted parentage in that state. Okay, can you modify child support up or down? Yes. What's our standard? It's just like modifying child custody. Substantial change in circumstances. Substantial change in circumstances on the part of either parent that would make the original award unfair or unconscionable. All right, so we need PJ, can be modified up or down based on substantial change in circumstances. The original award has to be unfair or unconscionable. Okay, so if the obligor's income decreased, the courts are going to look at whether that was voluntary or involuntary. So if it's involuntary, are they trying to restore their income, or are they just trying to get out of paying child support? Okay, child support is enforceable by the states. Any state, you don't need PJ. Any state can enforce the order of other states. Full faith and credit, remember? Okay, so how can child support orders be enforced? By any legal method, withholding wages, intercepting the person's tax refunds, garnishing their wages, suspending their driver's license and other recreational licenses, denying their passports, seizing their financial assets, their workers' comp, their lottery winnings, their bank accounts. And at worst, you get published on the most wanted or deadbeat dad list. Okay, so enforcement, how the heck do we enforce child support? How do we get these people to pay up? Civil or criminal contempt. Civil contempt will keep the person out of court so that they can actually work and pay child support. Criminal contempt is disfavored. Okay, we just finished everything child. That was fast. Now we're going to go to spousal support. Okay, we're talking about property and money? Yes. So what do we need? PJ, long arm, due process and service. Unlike divorce, spousal support can be fault-based, but here's the really important thing. Spousal support can be one of 5 types. 1, permanent. 2, rehabilitative. 3, reimbursement. 4, incapacity. 5, caregiver. Let's say those again. 1, permanent. 2, rehabilitative. 3, reimbursement. 4, incapacity. Or 5, caregiver. Okay, permanent would be awarded if we have a very long marriage or the spouse is disabled or can't work for some reason. Rehabilitative would be for a short duration to allow the spouse to get education so that they can earn their living. Reimbursement would be to reimburse a spouse for contributions made to the marriage during the marriage, say by staying home to take care of the kids. Incapacity, one spouse is disabled, or caregiver, and this is strictly to support a disabled child. Okay, for spousal support, do you just get it? No, you must demonstrate need. So, what is need? The person doesn't have enough money or property to provide for their reasonable needs, is unable to support themselves through employment, or they're the custodian of a child who needs full-time care. Okay, so what's need? Spouse doesn't have sufficient money or property to provide for their reasonable needs, and they're unable to support themselves through employment, or they're the custodian of a child that needs full-time care. Okay, so our source of law here, forgot that again, is the UMDA. Okay, so we're going to consider 8 factors when we're thinking about support. The age, the physical, emotional condition of the spouse. How long was the marriage? The marital standard of living. Whether the spouse can meet their own needs. The time for the spouse to get trained or educated. What property was granted to that spouse in the divorce? And of course, we're going to look at the obligor spouse's ability to meet their own needs. All right, spousal support. What's our source of law? UMDA. What do we need over the defendant? PJ, long arm due process and service. Do we need fault? Maybe. What are our 5 types of spousal support? That's right. 1, permanent. 2, rehabilitative. 3, reimbursement. 4, incapacity. 5, caregiver. And we need to demonstrate what? Need. Doesn't have sufficient property or money to provide for their reasonable needs, and is unable to support themselves through employment, or they're the custodian of a child who needs full-time care. And we're going to look at the UMDA 8 factors. 1, age, physical and emotional condition of the spouse. 2, length of the marriage. 3, marital standard of living. 4, whether the spouse can meet their own needs. 5, time for the spouse to get training and education. 6, how much property was apportioned to them in the divorce. And 7, the obligor spouse's ability to meet their own needs while paying support. Okay, can you modify spousal support? Yes, you can. What does the original court have? Oh, yes, say it. Continuing exclusive jurisdiction. Continuing exclusive jurisdiction. And what's the justification? Substantial change in circumstances, just like child support. Okay, so for spousal support, this is a little bit different because the original terms must be very unreasonable or create an extreme hardship such that the obligor spouse would end up as a public charge, i.e. on welfare. Okay, so what happens if the obligor dies? Well, is that foreseeable? You're going to have a claim on their estate. What about if they retired, or do they get off scot-free from spousal support? No, not necessarily. What about the order expires? You can always argue for more time. Okay, spousal support modification, what's our buzzword? That's right, continuing exclusive jurisdiction to the original court. And we have an unreasonable change in circumstances, substantial change in circumstances, that's our standard. The original terms are unreasonable or create extreme hardship. And I think it's probably easy to figure out death, retirement, and expiration of the order. Okay, we're going to stop this one. Property division will be a separate video.